Yes.
Okay.
Okay. This is a meeting of the Appeals Board, and I turn the meeting over to our lawyer, Dan Pileggi.
Okay, before we get started, I understand that we need to elect board officers. I'd like to accept nominations.
Who is doing that?
You're doing it.
I'd like to nominate Ellen Doman as chair, Roger Samuel as vice chair. Sounds a little embarrassing. Linda Martin as secretary. Is that it?
That's it.
That's it, okay.
Any discussion, any further nominations?
All in favor? I now call the meeting to order. Appeals Board, July 8th, 2014. First order of business is to adopt the agenda. I'll take a motion.
I move we adopt the agenda as written.
Second?
All in favor?
Aye.
Unanimous. We have, I guess there are two excused absences. We have two sitting board members who did not get sworn in, and it's a small technicality, but apparently they are not allowed under our ordinance and town charter to serve tonight. So they are excused or I don't know what they are. Anyway, that's,
Can you help us with the word?
Excused absences.
Excuse
they're
absences.
excused, okay. Next order is to approve the minutes from back on the 8th of October, 2013. Anybody have any changes or additions, subtractions, corrections? If not, I'll entertain a motion.
Legal question. I was recused for most, but not all, of the meeting.
I think you can't vote.
Shouldn't vote.
That's what I would
Right,
think.
okay.
So we can't vote. We don't have,
Well, but they weren't even here, so they can't approve them, which means that this is one of those times when we're just going to have to accept them.
well,
On the face
I
of it.
would,
Yeah.
I would move that we accept them, and
Me too, fine, they're accepted. Okay. Regular business. Okay, as secretary, you will read this thing. Yeah, that.
regular business. Public hearing, AB 2014-01, administrative appeal. Applicant Donald B. Murphy and Patricia D. Murphy. Project location 37 Woodbury Road, Bar Harbor, Maine, 04609. Application. The applicant requests that the Board of Appeals vacate the decision of the code enforcement officer to issue permit 12712 on December 10th, 2013 to construct a new substation and control structures.
I need to ask you, this says administrative appeal. Is this
It is.
an administrative appeal?
It's an administrative appeal of the CEO's issuance of a permit.
Okay, I'm a little confused because I thought it would be a de novo hearing.
Under the ordinance, it is that standard that you're going to consider. It's a de novo hearing. It's an appeal of a code enforcement officer issuance of a permit.
Okay,
It still comes under the administrative appeal language of the ordinance.
okay, thank you. Okay. What I would like to share with all of you at the table is that for any of you who has worked with the Appeals Board in the past, I think you're well aware that we come extremely prepared to our meetings. We do our homework. So what I would ask when you present to us is to understand that we really have read all the material that you've given us. And therefore, if you will summarize your high points, emphasize to us your positions, but you don't need to feel that you need to walk us through your presentation. Thank you. Okay, we will start with the appellant.
Is this microphone going to pick me up?
It's
if I
supposed to,
stand?
that one that's there is
The
supposed to,
upstanding?
but I mean, you want to stand?
Yeah.
Would you rather stand at that one? It's entirely up to you.
This works for me.
Okay, that's fine. If
Yeah.
you're not heard, he'll tell us anyway.
All right.
Richard, did you want to take up the standing
Oh,
issue?
right. Absolutely, you're right. I'm sorry. There's an issue before you. I forgot. The issue first is a question of standing. Generally speaking, our LUSO talks about, is it 200 or 300 feet abutting? 300 feet abutting. The appellants are more than 300 feet, so the issue is, do they have standing to bring this appeal?
We could ask them if they want to.
Well, I can remind us of our history on this. Would that be useful?
Well, I know we generally tend to interpret things broadly.
And I think there's legal precedent for that. Remember when Phil brought us that Sierra Club case where the people didn't even live in the state, but because it was close to a national park, the court found that they had standing because it impacted on them. And traditionally, we have always been quite liberal in the granting of standing if somebody is significantly impacted by something that was going forward. We have granted them standing.
Now, would it be good to allow the two sides to make a statement as to their point of view on that?
There's been a submission, I've read the submissions, I've seen an argument about standing by the applicant. I don't believe I've seen a response from anybody else.
Right.
It may be to the board's benefit, it may help the board to understand the issue and rule on it if you hear from people that contend that there is no standing. The determination you have to make is whether there's going to be whether they would suffer a particularized injury.
Mm-hmm.
But that's the board's pleasure.
That's fine. Would any of you care to speak to that?
Madam Chair, James Collier for the appellants. We have, as Mr. Pelleggi so rightly points out, put in our position of appellant an argument about standing. We also have prepared, if the board wants to hear it, Dr. Murphy could tell us about what she's particularly concerned about, which is noise. So the section is in the LUO 12509, an aggrieved person, an owner of land is directly or indirectly affected by the granting or denial of the permit. Her particular concern is noise. So we're prepared to, for a presentation, 5 to 10 minutes on possible effects of noise, if need be. Thank you.
Okay.
Good evening. I would like the opportunity.
Can you identify, there are no names in front of you, we don't know who you are, so you need to identify yourselves, please, and who you represent.
My name is Tim Pease, and I am corporate counsel for Amera Maine. I know this says Amera, but it's actually Amera Maine. That is the company's name. And I want to address the issue of standing. I think it really has two components that I want to address. And the first is what you just talked about, which is the distance from the particular site. And as the appellants admit, they're more than 600 feet from the site. I noticed in your notice of hearing tonight that mailed notice goes out to abutters within 300 feet. And the appellants have admitted they are not abutters to this particular site. and they're more than twice that distance. So even under your own notice of appeal rules, they would not get notice of this. And there's a reason, it's an important reason, that you have limits for standing. Otherwise, it becomes open season for any permit issued in any part of the town. I understand you have a broad interpretation of that, but at some point you've got to say, this is too far attenuated for this land to be impacted by the particular activity. The appellants have had an opportunity to submit their notice of appeal and also their argument and evidence ahead of time. And although Mr. Collier mentions noise, there's nothing in those documents, nothing in the evidence that's been submitted so far to document any sort of noise issues, what the noise levels will be, more than 600 feet and uphill away from this site. So on the issue of whether they are an aggrieved party, under your ordinance, I don't think they qualify. The other aspect of standing, which I think we need to not lose sight of, is the timing of this.
Okay, that's going to be a separate issue next.
Very good.
Standing and timeliness we're dealing with separately.
Excellent. Thank you very much.
Madam Chair, Rob Crawford for the Code Office in Angela. We also share the concerns about the appropriateness of the parties that are before you tonight in terms of their standing. I took a look at their submissions, and when I read through, a couple things jumped out. First of all, as you know, your ordinance talks about and defines the aggrieved party as a person directly or indirectly affected by a grant of permit. And we now know that the location of the appellant's house is over 600 feet from the situs of the activity, which is the subject of the permit. And one has to think about, in terms of just as a matter of policy, where do you feel comfortable in extending that to the parties that are before you? I've gone to visit the site, I've looked at the site, and I've also noted from looking at tax maps and aerial photographs the locations, the proximity, and the distance. And one wonders if this is, if these parties are standing as an appropriate aggrieved party. The other piece of your aggrieved party, obviously, abutters. And Mr. Collier makes a point that sometimes it's not a direct abutter, but it can be a person across the street. But I think we have here, 2 streets removed, around the corner, around the bend up to where the appellant's location is. And the last piece about the aggrieved party is the particularized injury piece. And I think your reference to the Sierra Club case triggers all of us that are sitting here in the legal profession on that one. And the concept there is that the parties that are before you really have something that's different than the public at large in terms of the damage that's going to be caused or the harm that's going to be caused to them. And so our concern is, just as a matter of administration, however you decide, that you carefully understand that you're looking at this and potentially creating some mischief down the road if this isn't decided correctly. I'll reserve my points on the timing. I also consider those as a fundamental preliminary matter that needs to also be carefully considered by the board. Thank you.
Thank you.
Madam Chair, brief rebuttal.
Okay.
In the materials we submitted in Appellant's Exhibit 3, which is the case of Saul versus the Town of York, and Appellant's Exhibit 4, which is Single versus the City of Bangor, the law court developed a neighborhood test. People were affected in the neighborhood. To my knowledge, unless Mr. Plagge or the other attorneys can come up with a case, I don't remember seeing in my 15 years of practicing municipal law a set distance. I understand that the town has noticed the 300 feet, but the test is the neighborhood, people affected, and there's no set distance been set by the law court. Thank you.
Was that yours? I'm sorry. Sorry. Okay. What do you think?
I would have to say then I have to go back to the beginning here, to what the definition of the village residential is, which is 125-20. And I'll read it. The village residential district encompasses the well-established residential neighborhoods that surround the traditional downtown area of Bar Harbor. It consists mostly of single-family homes, but also includes condominium, multifamily, and non-intensive commercial uses. New development, redevelopment, and infill development shall respect and reflect standards to assure the uses are compatible with any nearby properties. I don't know if that helps, but that's what it says. Yes.
If I may, I don't think that it's appropriate for the board to, I don't think any decision by the law court has ever suggested that everyone within a particular zoning district in a town would have standing to
Okay.
appeal a permit issued
Okay,
to
I
a
just-
single property owner.
Okay, I just bring it up.
The law says the cases that Mr. Collier cites are where people didn't live exactly next door, but they
Right.
could show a particularized injury.
Right.
That might, one of them, the Saul case, I think was a motel, that was gonna block somebody's view, and it was a couple of properties
Right.
away. That's the type of analysis the board should be engaged in.
Okay. May I ask another question?
Of course.
Is the issue of the noise something that is relevant for people outside the 300?
I think that's something for us to decide. I think that's our
Okay.
call.
Okay, okay. I just want to bring them up so
Right,
that.
absolutely,
that we-
absolutely.
Okay.
I mean, we would certainly have a problem with the 300 feet if we were talking about building a 1,000 megawatt power plant, which is going to be, in effect, a miles away.
Excuse me 1 minute. I'm sorry, until what I do is call an open public hearing, it isn't open to the public. There will be a time for you to talk, and everyone in the public who wants to speak will be allowed to speak. And I will declare an open public hearing at that time. I'm sorry, Roger.
No.
So where are we?
So there's a range of where I would be inclined to expand the 300 feet to. And this board has been very generous in expanding. I don't remember which the case was, but eventually the position of the board was anybody in town had standing, given the issue. So we have.
We have precedents.
Although we're not stuck to following precedent, we do have history of expanding it. So what do you think?
I guess, having been schooled by Phil, excuse me, I completely neglected to say, and I should have said it before, right after being elected, I think I was thrown off by the fact that two of my board members can't sit, and I lost my focus. We have had a lawyer for more than 10 years, Phil Warden, who was simply and plainly terrific. We loved working with him. He was wonderful. We learned a tremendous amount from him, as you'll hear as we go through. And we want publicly to thank him so much for all the help, the guidance, the gentleness, the humor, the thoroughness that he brought to everything he did with us. I would also like to commend my two board members who have stepped down and have been long-standing board members, Paul DeVore and Mike Saglosi. They were wonderful board members, always prepared, always careful, always intelligent, always fair-minded, helpful, and it was a real pleasure to serve with them, and I will miss them all three very much. And that should have been said at the outset. I'm sorry. Now, to say what Phil did teach us, which is that when you take standing away from somebody, you are really ultimately usurping a very basic right of people to be part of a community, to feel that they are invested in a community and how it goes and how it works. And it disenfranchises them in a way that we have heretofore not exercised, unless it's something really out of the blue that somebody just wants to stop something because they have a personal feud with their neighbor or something that is not germane to the well-being of an entire neighborhood. And I guess in seeing this as something that is impacting on a larger than just 300-foot neighborhood, I personally would be willing to grant standing. How do you all feel?
I do too.
Okay, then let's have a vote on that, please.
So to be clear, the vote's going to be that you're finding that they're potentially aggrieved and would suffer,
Granted,
have shown
A
that they
particularized
we
injury.
have the other issue for standing, which is
Yeah.
the timeliness that you
Right.
haven't addressed yet. I
Right.
just want to make that
Yes,
distinction.
thank you.
Okay.
Okay, all in favor of granting standing? Unanimous. Okay, our next issue is timeliness. We have a 30-day limitation on here on somebody appealing. Would you like to speak to that?
I would. We have two arguments on that. The first one is Justice Alexander's minority dissent in Brackett versus Town of Rangeley. It's that any judgment that's unlawful can be collaterally attacked at any time. And then later on, that opinion was given the stamp of approval in Nestle Waters versus North America, which we cited to. So it's now the law in Maine that, so if something's unlawful, if it was issued unlawfully, like a permit that was issued unlawfully, which we propose that we'll show the board that it was issued unlawfully, and hopefully the board will agree with us, then there's no time limit. You can attack it at any time. So that's our first argument. The second argument is the one that's been developed on the law court called a good cause exception. If you weren't in town, or there was some number of circumstances that you're unaware of what was going on. And as we've shown in our exhibits, which I can cite to if the board would like, the Murphys were out of town when this happened in December. They got back in town, as many people do around here, in May. They noticed a clear cut and went, wow, what's that? A couple days later, they were, as they often are, down at Parsons getting some fish, and said to Ms. Parsons, what's going on over there? And she said, oh, that's the industrial substation being put in. Let me give you some literature on that. And they got that about May 8th. And within 30 days after that, although the 30-day time period is not conclusive, but it was within 30 days, we filed the appeal. During that period, they were busy looking for a lawyer, talking to me, other attorneys, trying to figure out what to do about this. So they were, as the court notes, diligent. That's what you're looking for, is diligent in prosecuting their opposition to the matter. Without getting too technical, there is an argument about remedies and whether a board can get into an equitable remedy versus a legal remedy. And the court has said that this is something that generally, not always, but generally should not be done because it's an equitable remedy by the Board of Appeals. But the court doesn't say that the Board of Appeals can't do it. They just disfavor it unless the circumstances are clear.
I'm unclear as to what you're saying is disfavored?
What's disfavored generally is a court on a timing matter allowing a good cause exception, such as I'm trying to argue for.
A municipal board, you mean?
A municipal board, before a municipal board. The court generally wants the court to do that, not a board.
Oh, I understand, okay.
And they say that, but they then go on to say very specifically and narrowly, and this is, I apologize for testing the board's patience on this, but this is generally the case, but not always. Generally, it should be reserved for the court, but they say where there's a clear-cut case, it could be reviewed by the board itself. Here, I think we obviously have a clear-cut case. I don't think anyone's going to argue that the Murphys were out of town. When they came back, they went, oh my God, look at that, what's that? They asked around the neighborhood, and then they, as quickly as possible, got their act together and filed an appeal. So I think this is a pretty clear-cut case. So our second argument is that the good cause exception to the 30-day rule created by the law court to prevent a flagrant miscarriage of justice, this is a good case for application of that.
Thank you.
Thank you.
Yes. Tim Pease again. I'd like to address Mr. Collier's first argument that this decision could be attacked at any time. And he mentioned an unlawful decision. We don't have an unlawful decision here. What we have is the appellants attacking the discretionary decision of the code enforcement officer. There's no question that the code enforcement officer had the authority to make an interpretation in this case. It's not like the code enforcement officer acted outside her authority or had no authority whatsoever to do this. She did. The appellants disagree with that. That doesn't make it an unlawful decision. That doesn't mean that somebody could come forward and attack this permit at any time in the future, no matter how far distant from the issuance of the permit. Then the issue is the good cause exception. And Mr. Collier was kind enough to submit several cases on the good cause exception with his materials. And I think you'll find if you read those cases, or if you ask the attorney to read the cases for you and give his interpretation, you'll find a common thread to when the court has said the good cause exception applies. All of the cases submitted involve abutters, not someone far away, far removed. All of the cases in the materials involve people who acted immediately upon finding out that there was an issue. Mr. Collier said that on May 5th, the Murphys came home and said, wow, look, a clear cut. But no appeal was filed for another 32 days outside of your appeal period. Which brings me to another common thread. All the cases submitted by Mr. Collier all showed that the people filed an appeal within the appeal period, not after the 30 days, within the appeal period. So if you're trying to figure out whether this particular situation you have with the Murphys fits with any of the cases that you've seen in the past, I think you have to conclude that the good cause exception doesn't apply. The Murphys are not abutters. They filed after 32 days, and there's no evidence that they did anything other than try to find attorneys. They didn't come to the town or anything like that to try to do anything. The good cause exception doesn't apply in this case.
Thank you.
I won't go into that in detail, but there's 2 points that I would like to add to the record. And these are included in the appellant's materials at number 8 and number 9. Number 8 is Mr. Murphy's affidavit. He talks about that it was on the 5th, which is a Monday, where he first noticed the construction. And then he had the exchange with Ms. Parsons, and her affidavit is number 9 in the materials. On May 8th, which is a Thursday, when he learned about that Emera was proposing to construct a substation. And as part of Ms. Parsons' affidavit, there's actually appended to it as an exhibit that talks about a May 1st meeting with some of the residents with Emera Maine about the substation. So while Mr. Pease has identified a 32-day period of notice.
Excuse me a minute. I'm sorry.
A notice or ability to respond, I think you need to also see whether or not there was an adequate opportunity for other folks to come forward with due knowledge and due dispatch to make the appeal deadline. We concur with some of the points that Mr. Pease just made too, that this is usually a pretty stringent test. Either you're in at 30 days or you're not. And at least my reading of the Brackett case suggests that it is only in the purview of the courts to make this application of expanding that deadline for those unusual exigencies to avoid what's known as the flagrant miscarriage of justice. So I hope you'll consider those points carefully.
Thank you.
Thank you.
you want to talk again?
I do, a very brief rebuttal on each point.
Very brief.
In regard to the first point, Mr. Pease's point about their jurisdiction when to make a discretionary call, she's the appropriate person to issue or not issue the permit. However, as Mr. Pelleggi will no doubt advise you, in Latin they call it jurisdiction strictu sensu, or jurisdiction in the strict and narrow sense. Her jurisdiction to make discretionary decisions is extended to exactly where she makes an unlawful one. When she makes an unlawful decision, a decision that should not be made, she no longer has jurisdiction. So that,
I think I'm going to have to cut that off, only insofar as I think you're talking about the heart of the case, and right now we're talking about timeliness. So I'm going to ask you to put that on hold, if you please.
sure. And then the second one, the butters only, but they don't say that's limited to a butters in the other cases on the timing. And within the 30 days, I mean, I didn't think we were going to get into 30 or 32 days. I don't remember anything in those cases talking about 30 days. But the fact is, the Murphys did what you would do. They arrived back from being out of town. They asked around the neighborhood after they saw the clear cut.
We got it, thank you. Okay. What do you think?
Well, I would favor saying it's timely.
Okay, you want to,
Do you want to talk about it?
It doesn't matter to me how the board rules on this. When you make a vote, however you decide, I think it would be helpful to refer to section 125-103, which talks about the timing. You have a 30-day, your authority, based on the ordinance, is to hear appeals when they are filed by an aggrieved party within 30 days of any decision. There isn't a good cause exception in the ordinance itself. The board needs to make a consideration of whether there's authority to go beyond the ordinance terms and apply a good faith exception. If you then decide to do that, council's correct that the appropriate standard finding you need to make for good cause that courts have applied is that there needs to be a showing of a flagrant miscarriage of justice in order to allow an appeal that is untimely. So just to make sure that your record's clean in case this goes further, I'd ask you to address those issues.
okay, so we're addressing flagrant miscarriage, and the other is,
The other is the board's authority to do something that is not, to take a step that's not
not,
set forth in the ordinance.
not Luso. Okay. Roger, I'm still willing to hear you.
Well, I'd like to hear Dan talk. That sounds very much like a strong caution that we shouldn't do that.
I can't tell you what to do.
No.
I think that all council, what we've heard from all three of them, is that the law court, when the law court has applied the good cause exception, it has done so at the, or it's either suggested the Superior Court had authority, or it's suggested that Superior Court should have made the considerations. I'm not aware, and council haven't made me aware of a decision in which the law court has suggested that a municipal board has authority to exceed the terms of its ordinance and apply an exception. Your ordinance doesn't have a good cause exception.
Can I ask a question? Have we made exceptions? I haven't sat that often. Have we made exceptions before?
I know we've turned down appeals.
When they were, yeah, that were not timely.
Right.
Yes.
They were not this complicated.
Not of this
These are-
magnitude. When we've turned it down, it has really been something that was uncontested between two neighbors, and then the neighbor who's contesting it, whatever the neighbor's doing, they decide they don't like it after the fact. You know, oh, I didn't know you were going to put up a garage that I think is ugly, I don't like
Right,
that color.
right,
You know, and that sort of, it's
Right.
been not I think our decisions have perhaps not been germane to this question, or at least in my memory. That's about 10
You
years.
have a long memory.
Yeah, so I think that's probably not going to be a direction that's going to help us, unfortunately.
Well, I guess in light of what our counsel has said, and given the nature of the parties involved in the dispute, I think we should say it's not timely, because this is going to end up in court.
Okay, I'm going to
And let-
present a different
And
opinion.
let the court figure it out.
I think one of the things that Dan and I were discussing before the meeting is that our LUZO is very careful in allowing us to do many things in the context of LUZO, and reading certain things in a way that comes within a context. If you look at the context of our town, for starters, if you were not notified, and the Murphys were not notified. So theoretically, and if you accept, as we did in allowing them standing, so we've already established that they are impacted in their neighborhood. If we then say that that neighborhood and that change in their neighborhood impacts upon them, and we granted that in standing, then we say, well, then if they were not notified, it follows that a 30-day trigger would not necessarily have started at the time of the issuance of the permit. The other context that I have for our town is that we have two very different populations, and we, as a volunteer board, serve both. One is our year-round population that obviously reads and knows everything that's going on, everywhere, and the population that isn't here, that still pays taxes, owns property, is impacted. And I would say that the Murphys fall in the second group, but it's a legitimate group in our town. My feeling is to go with your original statement, which is that I think we have a legitimate reason in accepting a broader sense of neighborhood on something that is as impacting as an electrical substation. It isn't a driveway. It isn't a curb cut. It isn't a fence. That in looking at that and broadening our sense of neighborhood, who is impacted, and then how they were notified or not, and when an appeal is timely, I would tend to be quite liberal.
Well, I agree basically with the philosophy that you're stating, and in fact, the fact that we're talking about 30 versus 32 means that we have extended the deadline by one train of argument by 5 months already. We're counting from May 8th or May 5th or whatever. The permit was issued in December. And that, to be strict, that's when the clock started running, correct?
No.
No?
Under your ordinance, the clock started running when the permit was issued. If you're applying a good faith exception, you find that the ordinance allows for a good faith exception and you're going to discuss that, then the time that they learned of the issue is as reasonable place as any to start that discussion.
Right,
But your ordinance doesn't say that.
right.
This is probably not even germane, but I'm going to bring it up anyway. If the neighbors had been notified, I believe, and I'm perfectly willing to believe I'm wrong, that it would have been neighbors within 300 feet. So that the Murphys would not have been notified anyway.
That's true.
Is that
'Cause
right?
They were. You gave us a list of abutters, so I assume they were notified.
No.
There wasn't,
No.
oh,
They were
no, you
not.
didn't notify anybody?
No, but
We only notify within 300 feet.
Yeah,
They are
but-
not within 300 feet.
No, no, I understand that, but
But you
within
did.
300 feet, the people were notified. I had a list.
Yes.
For this hearing.
Okay, I can't open the public hearing yet. In our packet, I received a list of 300-foot abutters, and my assumption was I was given that because they were notified.
Yes,
Thank you.
They were notified of what?
the appeal.
Yes.
Oh. Oh, they were notified of the appeal, they weren't notified of the substation.
There's no
Oh,
notification requirement.
okay, thank you for that clarification.
That's where I was going
Okay,
with this.
thank you for that clarification.
yeah.
Okay. So, in fact, we're now saying that this installation was not notified to any of the neighborhood on the initial issuance of the permit. That is a piece of fact. I think that's a very relevant fact.
Well, because of some of the issues that will come up if
Come up.
we
Right.
Right,
continue the
Right.
process.
right. But yeah, that's what I wanted to get out, is that no one was.
Okay, okay.
So I don't know what that does for us, but.
Well, I guess my feeling is that in something that is clearly not a telephone pole, the impact of the installation is way larger than might make for a comfort level in a neighborhood to have that degree of change occurring in a neighborhood. And I don't think anybody could maintain that it's not a significant change in that neighborhood. I guess I think it provides us with a strong enough case to say that the limitation of 30 days is a technicality on abutting neighbors being informed, having a right to bring an appeal, that this is not one of those after the fact, it's open season on what I don't like, and therefore we need to limit to the 30 days. I think we are within our right to expand that.
Well, I would just say that the abutters were not notified, period. So then when somebody finally did, we expanded the time. And if we get in trouble, we get in trouble.
Well, the point is that anything we do, the law court can overturn.
Right. Right.
This is absolutely within their purview to say, they overstepped their right.
Right. They can fire us.
No, not
I
pay
don't
us.
think so, but the court can overturn us.
Right.
It would be a first, but
Right.
that'd be okay.
Good. So if we were to go ahead, what should we be doing?
I would suggest if the board is going to address a good cause exception, you need to find out where that good cause exception exists within the ordinance, and then you have to
Well, you said
apply-
it didn't exist in our
It doesn't.
And
ordinance.
then you have to apply the standard, which is a flagrant miscarriage of justice, which is what good cause means under the law court's definition. So those are the two issues you need to find.
But he said we can't do
Can't
that.
do that.
So,
Flagrant miscarriage of justice. There's a big phrase.
I don't think we have any choice.
Can we adjourn for 5 minutes while I confer with my lawyer? Can I do that? Am I allowed to do that?
Boy, now I'd like to hear what he has to say.
Invite Mr. Collier to come.
I don't, to be honest.
That, I don't know if that's legal.
I don't know that, since we've opened the hearing, I don't know that we can.
Do that?
go to
Okay.
executive
Well, then I need to, I need to hear from you. To say, I mean, the language is so damning flagrant. I mean, I'm not going to say Angie made a flagrant mistake. I may disagree or not disagree as the case goes forward, but flagrant anything, is
The
such
flagrant-
a...
You're not even getting to the point of what the code enforcement officer did or didn't do.
Right.
The question is, A, can you apply, is there some way that you can apply a good cause exception under the ordinance? That's the first question that the board has to reach. And then if you can, if the board decides that it can apply that exception, the flagrant miscarriage of justice that you have to determine is by denying the applicants a hearing based on their particular grievance or particularized harm that they're going to suffer by not being heard. So what the law court has applied, special circumstances relating to the delay, special circumstances relating to the inability to meet the standard of the ordinance, which is here, it's 30 days. You only get to that if you can get to
That's the
hop
first
over
one.
the first step.
And the first step is that in denying the appellants the right to be heard, that would be a flagrant miscarriage of justice?
Well, you have to find that you have the right, as a board, as a municipal board, you have the right to apply some standard that doesn't exist in the ordinance. And if you do, then the standard you apply is whether there would be a flagrant miscarriage of justice by not letting them be heard.
Oh,
You've
okay.
talked a lot about that second
Yeah,
piece.
I
The
could-
first piece you guys need to discuss
I don't think we have.
is
any
whether you have the
issue
authority.
about
And
the
I-
second part,
Okay.
but
All
our
right.
counsel says
Okay,
flatly
so-
we do not have.
Do we have the right to overstep LUSO, is the issue we're debating?
I'm happy to, I don't know if Mr. Collier said that there's some suggestion that the law court's made that says municipal boards can apply a good cause exception that doesn't appear in the ordinance.
I had that.
And if the board wants to listen to council talk about that issue, that's
Sure.
certainly
Absolutely.
helpful.
Sure.
Very briefly, Madam Chair, thank you, Mr. Pelleggi. In Exhibit 5, which is George Brackett versus the Town of Rangeley. Oh, it's Exhibit 5. In paragraph 24 on page 14. No, it's 5.
Okay.
You all set?
Yep.
Yep.
So paragraph 24, it's the one, two, it's the third last sentence, which starts with, "in the instant case." In the instant case, because there are extenuating circumstances, the board clearly erred in denying the brackets the good cause exception. The board clearly erred. So to Mr. Pelleggi's earlier point about an example where it was the board, not the court, there's an example right here. The court's saying the board clearly erred. And then they go on to say, the town's error precluded the use of that period, effectively rescinding it. And while the appeal period existed on the books, it did not exist for the brackets. So I guess I just wanted to point that out because that's what could happen here, is I don't want the board to preclude something that's available to my client. Also, very briefly, in regard to the flagrant miscarriage of justice, very simply, when the code enforcement officer, and we're sort of circular here, we have to get into the merits case, which we won't do now, but if you agree with us that the permit should not have been issued, what we would
It's yet to
see,
be determined.
that's correct, what we would see as a intensive commercial or industrial use would be put into a residential
Okay,
neighborhood.
I need to cut
That's
this off.
flagrant.
This isn't, okay, but that isn't what we're debating now.
If I could just
Sure.
address that point. If we could stay in tab 5, earlier on in that case, in paragraph 17, it says, although we review most factual determinations of an administrative body deferentially, we have decided that the application of the good cause exception is a decision to be made judicially rather than administratively to prevent local arbitrariness.
We understand that. That we do really understand.
In other words, it's.
We
decision
really
reported.
understand that.
Now, question, is it common that Luzos do provide for such exception?
I know it's uncommon, at least in my, listen, I work in a limited region in the state. In my experience, it's uncommon to have a good cause exception. I
Right.
have seen ordinances
You have seen.
that have them.
We know in the case here.
I don't know, just so you understand, that in order for the court to apply a good cause exception, the court has to find that a board erred. Doesn't mean that the board has authority or doesn't have authority. That's why you have contradictory language in the case that both lawyers have pointed out. Okay, so use the guidance that you have in any way that the board sees fit, but they just need to make the findings in those two areas.
In reading that bracket case, by the way, which I did, on page 4 of that, the top sentence, it says the brackets receive no notice of the permits. That was one of the basis for this particular case, meaning that the abutters and the extended abutters fall into that category. When I was reading it, I noticed that.
But I would have to say that the abutters were not notified at the 300-foot, and the Murphys would not have been notified
Even then.
even if the abutters had been.
That's true.
So, I mean, I don't know why I'm adding that, but it's,
Yeah. Well,
No,
again, and we have gone very far beyond the most narrow construction of the Luso in that we're talking about starting the clock in May, not starting the clock in December, the way you could very well interpret the Luso.
I guess where I come down on this is saying that in that our ordinance, as you say, the majority of ordinances in Maine does not address good cause, that is a really legal thing to do. It leaves it to us to interpret whether we want to go forward with this or not, because we have no concrete thing saying we can't. And then we get to flagrant miscarriage of justice, and if we apply that to a right to be heard, I'm perfectly, much more comfortable with saying that we might be committing a flagrant miscarriage of justice in refusing to open a case when something is as impacting as this utility substation, and is clearly involving as much of our community as has shown up. I think, have I addressed both horns of that dilemma?
You've certainly addressed the issues. I think the board's got to make a decision. I mean, I think that further discussion of the standards is going to be going in circles. If you have additional questions, I'm happy to answer them.
Okay.
so what is it that we're,
Can you suggest how we could justify giving a good cause exception?
If the board were inclined to do that, the board would have to, I would say, rely on some of the judicial decisions that have been discussed to suggest that the 30-day window, that is a pretty strict limit on your authority, ought not to apply. I'm not beginning to tell the board whether or not that would be upheld by a court, but that's the type of analysis that you need to engage in.
Well, I'm fairly comfortable with this bracket decision that allows for that. I think this case falls closely enough into it from my reading of it, of not, people not receiving permits. And therefore, the period extending.
I'm still having trouble, and it troubles me that I'm having trouble with the fact that this is not being brought to us by abutters.
Well, I think,
I mean, that's
I
just,
think
it's
we
just
already-
bothering me, so I just.
except that we already, I think we put that one to rest in giving them standing.
Okay.
I think that we're not debating that anymore. We would have had to debate that in standing.
Okay.
And I think the board made that finding unanimously, that it had impacted enough of the neighborhood that we now regarded them as,
Okay. As abutters.
yeah, I guess.
Madam Chair, just to
Absolutely.
address these issues, I mean, it's pretty clear that the wealth of law about what the authority of a municipal board is that you're constrained by the document that guides you, and that's your ordinance. So whatever authority you have is set forth in the pages of your land use ordinance.
And you cannot suggest to us any way to read anything in the Luso which does give us the good cause exemption.
The way that I read section 125-103, it's a pretty strict
tight.
standard. And I think that's where we have to start when we talk about the board's authority. If there's a way around that, I'm listening to the board, I hear the desire to do this now, and I sympathize, but we have to find authority within the ordinance to be able to do that. Now, just so the board understands, I mean, there's the opportunity that the appellants have made their argument on the standing issue, and they've submitted materials, and they've certainly created a record. And there's a record for either side to deal with at a Superior Court level on the standing issue. So, I mean, however the board wants to go on this, I think the record is preserved for everybody.
How about a very liberal reading of 125-103 D2A, page 125-136 in mine, but that may not be the correct page anymore, which says, I'll read it. It's under evidentiary hearings.
Okay.
Appeals from a notice of violation, the granting of a permit by a CEO, and all other decisions or actions taken at which the appellant did not have a fair opportunity to present evidence to the decision maker shall be by evidentiary hearing. By extension, could that
Smiling with you, not at you.
could that be at least an opening to an opportunity for us to say that the 30 days notice therefore was not an opportunity to present evidence?
I don't know how to answer that question. The context of that section is discussing the nature of the type of hearing that the board is
Yeah,
supposed to
well, we're having an evidentiary hearing.
to conduct. It's not addressing the board's authority. The board can certainly use anything within the context of section 125-103 to discuss its authority and in the timing of an appeal and whether or not there's a good cause exception. But again, we've had discussions that we need to follow the ordinance and deal with the context that the ordinance provides to us, if there's an ambiguity. You only get to context if there's an ambiguity.
Nice try, but no cigar.